good?
Do you want to make any argument based on your motion?
You told me never to speak to you again. There's a conflict of interest between you and I. You claim that I threatened you by exercising my constitutional rights in front of your law firm, and you were so worried about it that it influenced your decision. So I can't get a fair trial with you, obviously.
County?
I did review the motion this morning. The rule that Mr. Filax is citing to is rules of judicial administration. So again, it applies to judges and courts. Failing to recognize this is not a judicial proceeding. I think the best standard to govern this proceeding is, Mr. Maggard, you're an extension of the Board of County Commissioners, essentially is sunshine law. So when does a commissioner have to recuse themselves from a proceeding? It's not the standard articulated in the judicial rule about what would a reasonable person believe, but rather, is there a conflict or an appearance of a conflict of interest? The closest I could find was Florida Administrative Rules 12D 9.022, which governs special magistrates for property appraiser hearings, and that is the standard that's articulated. So I would argue that, to my knowledge, special magistrate, your only interaction with this appellant is in the context of these hearings. Yes, there was a prior case over the summer that did not resolve in his favor. This is a new case, new witnesses, new evidence. I don't know how having a prior case in a similar forum rises to the level of a conflict of interest.
It's not about having a prior case. It's about our email exchange where you told me never to speak to you again and that I was threatening you and that you're going to take action on my threat. It has nothing to do with the prior case.
Well, I don't think I, first of all, ever said never to speak to me again.
I can show you the email right now, sir, if you'd like. Would that help you remember?
Fine, if you want to present something you never printed out.
Oh, I'll gladly show you the email where you told me never to speak to you again or contact you again. And that you were going to take action against me as a threat. So there's an obvious conflict of interest here.
I do remember the exchange after the last hearing.
Correct.
So it was after the decision was already made.
Correct.
And you wanted to readdress it, and I kept referring you back to the county and saying that my engagement for this matter was done. Once I signed the order, you need to contact the county.
And you refused to show me where it says I need to contact the county after I asked several times. I don't know why I would contact a prosecutor who was working against me. That doesn't make any sense to me.
Once I ruled on the prior hearing,
Would you like to see
I
this?
didn't have any ability to do anything.
Would you like to see your email?
Sure.
Your threat has been noted and is being reported. Do not contact me again.
May I look at the email?
Go ahead. You're worried that I was going to protest in front of your lawyer's office and disparage you in some fashion or form. I would have contacted you and sent you this paperwork, but you told me never to contact you again, so you're also diminishing my ability to get the process.
think it's clear that my context was in regard to the prior order that you kept.
What threat did I make?
To readdress.
What threat are you claiming I made towards you?
I'm not sure. I don't even remember the incident, so I'm clearly not.
There's a clear conflict of interest.
Well, if I don't even remember what it was, then I don't think it's a conflict.
It's not based on your memory, sir. It's based on factual evidence I just showed you.
Well, I'm gonna deny the request for recusal because I don't think it's making me impartial.
Okay, then I'm gonna have to refer you to the Florida Judicial Qualifications Commission because there is a conflict of interest. You told me never to speak to you again. You clearly have a bias against me. And you claim that I threatened you when I never did such a thing. There's a clear bias against me and a clear conflict of interest. If you move forward with this, I will report you to the commission. There's no reason I can't have another hearing officer.
County, do you have anything?
It sounds like what we're talking about is an ex parte communication after the last case closed, so
Irrelevant.
I would agree that that's improper communication.
Irrelevant.
We're here in a formal proceeding now, we're on the record. It sounds like Mr. Maggard was requesting not to be contacted ex parte. I don't think that rises to
Claiming a threat.
Obviously, if you feel it's appropriate, I would say the Judicial Qualifications Committee does not have jurisdiction over you. You're not a judge. If you think it's appropriate that there's an appearance of a conflict, then Mr. Felix would have to waive his right to the hearing within 30 days, as that expires later this week, and we don't even have another hearing officer to contract with. We would have to seek one out. But
I've given you plenty of time to seek another magistrate out. You told me to bring it up at the hearing. I would have brought it to your attention sooner, but I was told never to speak to you again because you claimed that I threatened you when I never did such a thing.
I think you're taking that out of context.
Sir, would you like me to read it verbatim to you again?
No.
Okay.
I
You claim that I threatened you, that you're going to take action on my threat towards you, and to never talk to you or contact you again. That is a clear conflict of interest. Plain as day. There's no reason you can't hire another magistrate for a special session, other than you don't want to. And that's not the only thing. You also ignored all the case law I presented last time.
Yeah, disagreement on how the law applies is not a conflict, and also me telling you not to contact me.
Based on a threat. Don't forget that part. Based on a threat I never made.
Like I said, I don't recall.
Regardless of your memory, sir, it's on paper, it's in writing, it's on the record.
I think the standard is whether I think that I can be fair and impartial, and if I don't remember that incident, I do remember you contacting me multiple times after the last hearing, and I told you you need to contact the county.
But you never told me what rule says I need to contact the county. The 66159 specifically says that you have continuing jurisdiction. It says nothing about them. Who else would I contact if not you? They're against me. You're supposed to be unbiased. So why would I call a person who's working against me? That doesn't make any sense. And nowhere in the paperwork or 66159 does it say I need to contact him for paragraph 7 of 66159. I contacted you, you claimed that I threatened you, and you told me never to speak to you again. There's a clear, obvious bias here and a conflict of interest. Clear. Clear as day. And if the commission doesn't have jurisdiction over you, I'll find the commission that does have jurisdiction over you. You move forward with this, it will be an unfair trial, 100%.
County, do you have any follow-up?
I don't think what he's presented rises to the level of conflict of interest. There was an adverse ruling, and he was instructed not to conduct ex parte communications.
Based on what? Your opinions? There's nothing on paper, there's nothing on record says I can't contact him. Ex parte is something you guys decided to use. I've never used that word. I used your public email, which I was instructed by Sam Bounty here, to contact you through your email I found on Google. I was instructed by him to contact you. I can show you that email too if you'd like.
I don't think the problem is that you contacted me as much as once I told you to contact the county that my involvement's done, that you kept contacting me.
Your involvement is done based on what? How is your involvement done? Chapter 7 says you have concurring jurisdiction after the case is over. It doesn't say anything about me having to contact the person who's working against me to speak to the person who has concurring jurisdiction. That's you alone.
I think we have a disagreement with the law, but, and I don't think it rises to the level of the conflict. So if you want to proceed today,
I would ask to proceed. I don't have concerns that rises to a level of conflict.
I do. I have major concerns, and I will follow up to the end if you proceed with this trial. There is a conflict of interest between you and I. You also claimed over a phone call that I was threatening you, and I never threatened you once. You're claiming that I've threatened you multiple times, and I haven't done it once. Not one time.
like I said, I don't recall.
Regardless of your memory, sir, it's on record. It's in writing.
I don't think that there's a legal conflict. I don't.
There absolutely is a legal conflict. You've claimed that I've threatened you and to never speak to you again. So am I allowed to speak to you right now?
Yes, I told you to stop emailing me about.
That's not what you said.
In the prior emails before that, I did multiple times.
Why would I stop?
You kept emailing me, and I said, stop.
Why would I stop emailing the magistrate who has concurring jurisdiction under 66159 and was told by the county attorney to specifically contact you? You should not push through with this. It's only going to get worse. All you need to do is reset this with a different magistrate and a different set of eyes. It's as simple as that. I tried to tell him ahead of time. He said, no, just bring it up now, and here we are. Instead of figuring out beforehand, we're sitting here with all these people here and all this tax money being wasted, arguing the point. There's a clear conflict of interest. You claim that I threatened you more than one time.
I've decided that I don't think there's a conflict.
There is a conflict. I've decided there is a conflict, and I showed you the paperwork and the proof.
And after this hearing, you can appeal it to the circuit court and
According to him, I can't appeal unless I hire a stenographer.
I can't speak to the rules on that.
Okay.
I believe that a recording of the proceeding can be transcribed.
Not according to Mr. Bounty.
I'm telling you that if you have a recording of the proceedings, you can have it transcribed and submit it with your appeal.
Okay, sir, but you should not proceed with this. There is a clear conflict of interest between you and I. And I do not feel I can get a fair trial with you as the magistrate here today.
I understand your objection, but I disagree. I think that can be fair and impartial.
I disagree. Obviously, you haven't been so far.
Let's have a hearing in the circuit.
Let's not have a hearing because you have a conflict of interest. And I demand you recuse yourself.
I'm not recusing myself.
Okay. So you're going to go forward with an unfair trial and a biased trial, even though you told me never to speak to you again.
Like I said, you can appeal to the circuit court. If the circuit court agrees with you that they think there's a conflict,
There's a clear conflict.
then they will make that ruling, but I don't think there's a conflict.
So you claiming I threatened you when I didn't is not a conflict of interest.
I've already decided that.
You decided for yourself that even though you've said that I threatened you,
decision that I'm not recusing myself, I don't think there's a conflict.
even though you said I've threatened you.
Mr. Brown, do you have anything?
Why can't I reschedule this with a fresh pair of eyes and a new magistrate? I don't understand that. What's the problem with that? Why do you insist on taking this case after we've had problems with each
I'm
other?
just doing my job. I'm hired.
Part of your job is to be unbiased.
I am unbiased, that's what I'm doing.
You're not. You claim I've threatened you.
Like I told you, it doesn't affect my ability to hear the evidence today.
I think it does. Of course it
I
does.
need to remember that. I remember you.
Sir, your memory doesn't matter.
It does, if that's the whole.
I remember that you did do that. I remember that you did. And I showed you evidence and proof with your own words and your own actions.
Okay. You want to proceed?
No.
Yes.
I understand you guys want to proceed because you're the only contracted lawyer, but there's a clear conflict of interest here.
Okay.
And I cannot get a fair trial with you as the magistrate.
Your objection's been noted. We're gonna proceed. You can participate or not participate, it's up to you.
Okay, even though there's a conflict of interest, you're still gonna proceed with this hearing.
We have a larger problem at this point. It seems the appellant is not willing to abide by the rulings of the magistrate. As you've indicated, he's welcome to exercise whatever appellate rights are appropriate. The ruling's been made several times now, and Mr. Felix is at this point.
I'm objecting to your ruling. It's obvious there's a conflict of interest.
Right, there's a procedure for objecting to a ruling, and that's appealing it to the circuit court board. There's an appellate division in the circuit court, and that's where it would go.
So I need to take you to court.
You would take my decision theoretically to court if you disagree with it.
Okay, I object to these proceedings going forward with you as my magistrate as there's a clear conflict of interest. If you proceed, that's on you.
Your objection's been noted, and I'm overruled your objection.
Okay,
So,
shocked.
before we begin the proceedings,